All right, today we're jumping into a really fascinating story. How does a country's legal system actually get built? We're going to trace the evolution of Sierra Leone's laws from its ancient kingdoms all the way to a modern nation and see how its unique history literally wrote the rulebook. So, let's kick things off with a big question. How does a nation's legal DNA actually come to be? Is it something you can design with a clean blueprint from the very start, or is it more organic, something that grows and adapts over centuries, kind of like a tree with deep historical roots? Well, Sierra Leone's story really unfolds in three distinct acts, and each one left a permanent mark on its laws. You've got the pre-colonial era, the colonial era, and of course, the post-colonial era. So let's start at the very beginning with Act 1. So, let's go way back. We're starting in a time before Sierra Leone as we know it even existed. The land was this patchwork of separate, sovereign kingdoms, each one ruled by its own king. Now, in these kingdoms, you didn't have the separation of powers that we're so used to today. Executive, legislative, judicial. Nope, it was all fused together. All of that authority, making the laws, enforcing the laws, and judging the laws, it all rested with just one person, the king. And this phrase right here, it's not just a saying. It was the literal reality of the time. The king was seen as the keeper of all customs and traditions, which made him the ultimate authority. His decisions were absolutely final. There was no higher court, no system for appeal. So, to disagree with the king, well, that wasn't just dissent. It was seen as a profound act of disloyalty. Okay, so that's Act 1. Now we're moving into Act 2, the colonial era, and this is a period of massive disruption. The arrival of Europeans is about to fundamentally change the entire legal landscape of the region forever. What's really wild is that the founding of the Freetown colony wasn't some big, thought-out imperial project. Not at all. It was actually the result of this incredible domino effect that started with a court case in London, way back in 1772. A judge ruled that any slave setting foot on English soil was free. Which sounds great, right? But it created a social crisis with a lot of newly freed but destitute people. That's when this radical idea pops up. What if we resettle them in Africa? Eventually, after a lot of struggle for the new settlement, it was officially made a British Crown colony in 1808. Now, here is the really crucial part. British involvement didn't create one big, unified territory. Instead, it led to this fundamental split. You ended up with two distinct areas: the colony, which was centered around the Freetown Peninsula, and the protectorate, which covered, well, pretty much everything else, the vast hinterland. And this wasn't just a line on a map. This legal division was deep. If you lived in the colony, you were considered a British subject. That meant you were under direct British rule and English law applied to you. But if you were in the protectorate, your status was completely different. You were a British protected person. This meant the British ruled indirectly through the local kings, which allowed the old traditional customary law to pretty much stay in place. So what happens when you have two legal systems in one place? You get two entirely separate court systems running in parallel at the same time. It's pretty wild. On one side, you had the English-style courts for the colony. On the other, the protectorate had its own native courts based on traditional structures. You can just imagine the complexity and the tension this created. Two systems, one territory. It was complicated, to say the least. Okay, let's fast forward to April 27th, 1961. Independence. A huge moment. But with it came this absolutely monumental task. The newly sovereign nation was facing a massive question. How on earth do you take this divided legal heritage and forge a single unified national system? The journey didn't just end with independence. The really decisive move came 10 years later, in 1971, when Sierra Leone officially became a republic. That was the moment they cut the very last judicial ties to the British Crown. It was like the final snip of the cord, paving the way for a truly autonomous national court system. And this wasn't just a name change. It was a complete transformation of the judiciary. The old colonial appellate courts were dismantled. In their place, you got the Court of Appeal of Sierra Leone. But the biggest deal by far was that the ultimate Court of Appeal was no longer the Privy Council all the way over in London. Now, the highest court in the land was the new Supreme Court of Sierra Leone. So, we've been on quite a journey here, from ancient kingdoms to a modern republic. What's the big takeaway from all this? What does this complex history really mean for Sierra Leone's legal system today? Well, the nation's legal system today isn't just one single thing. It's much more like a complex tapestry woven together from all these different historical threads. You've got the thread of English common law from the colony days, the thread of traditional customary law from the protectorate, and woven all through that is the new thread of all the national legislation that's been passed since independence. And all of this leaves us with a final big question to chew on. When a nation's identity is forged through a journey like this, from the absolute power of kings through a colonial system that was literally split in two, to a unified modern nation, how do those echoes of history continue to shape its identity and its path forward today?